Today I want to play for you some excerpts from the actual oral argument in the VanDerStok versus Garland case involving what the Joe Biden-Kamala Harris defines as ghost guns, which are really just privately made guns or unserialized firearms. Now, before I get to those excerpts, I want to remind you of one thing. If Donald Trump is elected president and takes over the Department of Justice with the appropriate personnel in charge of the Department of Justice, meaning the right Attorney General, the right Solicitor General, and so on, this ghost gun regulation promulgated by Joe Biden and Kamala Harris could actually go away by virtue of the same executive order that Joe Biden did to put it into place. It can be taken off the books, if you will. So keep this in mind, that it's possible if Donald Trump is elected, this regulation could be mooted. And I think there's a good chance that would happen. But that requires Donald Trump to be elected. But either way, I want you to hear from the lawyers back and forth, because I think it's important for you to see exactly what goes on in the courtroom as people fight for and often against your right to keep and bear arms. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Israel Disarmed: When the 10/7 Attacks on Israel Teach Americans About the Right to Bear Arms. All right, so today I just want to play a couple excerpts, the audio clips from the lawyers arguing back and forth, articulating their main points about why the government thinks that the ATF's expansion of the definition of firearm by regulation is consistent with the statutory definition of firearm as found in the Gun Control Act of 1968, and to hear really the summary of the argument by attorney P. Patterson on behalf of Jennifer VanDerStok and the other plaintiffs in that case, a case that arose out of a series of cases brought by the Firearms Policy Coalition. So anyway, I'm going to let you listen and weigh in yourself, because it's important for you to hear what people are literally saying in America's highest court about your right to keep and bear arms. Now, I want to remind you that technically speaking, this case is a turgid, boring statutory interpretation case as to what is Congress meant, or what did Congress mean when they defined the word firearm in a particular section of the Gun Control Act, and how far can that be interpreted, what is the scope, and so on and so on. So there's a lot of dry legal argumentation here, and this does not speak directly to the right to keep and bear arms, because this is not a Second Amendment case. This is really a statutory interpretation case asking, does the ATF or has the ATF exceeded its authority given to it by Congress, pursuant to really what would be known as enabling legislation for the sake of this discussion. So with that said, let's start off with the Solicitor General herself, Elizabeth Prelogar, an excellent attorney, member of the United States Supreme Court Bar, former Supreme Court clerk, a very powerful attorney, arguing on behalf of the Department of Justice and the ATF that their regulation that expanded the definition of firearm was perfectly fine under the law. Let's see what Solicitor General Elizabeth Prelogar has to say.
We will hear argument first this morning in Case 23-852, Garland versus VanDerStok. General Prelogar.
Mr. Chief Justice, and may it please the Court, the Gun Control Act imposes straightforward but essential requirements. Firearm sellers and manufacturers must mark their products with serial numbers, maintain sales records, and conduct background checks. The industry has followed those conditions without difficulty for more than half a century, and those basic requirements are crucial to solving gun crimes and keeping guns out of the hands of minors, felons, and domestic abusers. But in recent years, companies like the respondents here have tried to circumvent those requirements. They've begun selling firearms as easy-to-assemble kits and frames and receivers that require minimal work to be made functional. They've advertised the products, in their words, as ridiculously easy to assemble and dummy-proof, and touted that you can go from opening the mail to have a fully functional gun in as little as 15 minutes. No serial number, background check, or records required. Those untraceable guns are attractive to people who can't lawfully purchase them or who plan to use them in crimes. As a result, our nation has seen an explosion in crimes committed with ghost guns. In the face of that public safety crisis, ATF promulgated this rule to underscore 2 points about the Gun Control Act's plain text. First, a weapon parts kit that can readily be converted to function as a gun with common tools, often in under an hour, is a covered firearm. Second, a product is a frame or receiver under the Act, even if the buyer must drill a few holes or remove a few superfluous pieces of plastic to make it functional. Both of those points are consistent with how ATF has interpreted and implemented the Act across 5 decades and 11 different presidential administrations. Respondents now seek a sea change in the Act scope. They claim that if a firearm isn't 100% functional, if it's missing just one hole that could be drilled in seconds and immediately assembled into a working gun, that product can be sold to anyone online with no background check, no records, and no serial number. That contradicts the Act's plain text, and it also contradicts common sense. This court should make clear that the Act regulates these products as what they are, firearms and frames and receivers of firearms. I welcome the court's questions.
All right, so that was a very powerful argument by the Solicitor General explaining why they think that what they did was consistent with the law. But now let's hear from Jennifer VanDerStok's attorney, Pete Patterson, arguing that the ATF far exceeded its authority by deviating not only from 50 years of prior precedent as to how the ATF interpreted the definition of firearm, specifically frames or receivers, and also how the ATF's current definition deviates from the statutory language of what is a firearm. Let's hear what Attorney Patterson has to say here.
Mr. Patterson?
Mr. Chief Justice, and may it please the Court, this case turns on decisions made by Congress in the Gun Control Act of 1968. First, Congress altered the common understanding of firearm to include other weapons that may readily be converted to firearms. Second, in a departure from prior federal law, Congress decided to regulate only a single part of a firearm, the frame or receiver, and Congress did not alter the common understanding of a frame or receiver. ATF has now exceeded its authority by operating outside of the bounds set by Congress. One, ATF has expanded the definition of frame or receiver to include items that may readily be converted to a frame or receiver. And two, ATF has expanded the definition of firearm to include collections of parts that are not weapons and that do not include a frame or receiver. Some concern has been raised about circumvention, but of course complying with a statute is not circumventing it. And as this Court said in Abramski, which has already been referenced, Congress in the Gun Control Act did not seek to pursue its purposes of controlling access to firearms to the nth degree. And notably, Congress did not regulate the secondary market for firearms. And that secondary market is a much bigger source of firearms for criminals than privately made firearms. There also has been questions raised about the agency's prior practice. There definitely has been a sea change by the agency here. The agency projected that its rule would put 42 out of 43 unlicensed manufacturers out of business. And what the agency said in the Syracuse litigation was they said an unfinished frame or receiver does not meet the statutory definition of firearm simply because it can be designed to or can readily be converted into a frame or receiver. That's the exact standard they've now adopted. Instead, what they looked at was whether critical machining operations had taken place. And to be clear, we have no quarrel with that prior practice. We have raised as alternatives, one, something has to be completely machined, or two, the critical machining operation test. And the latter, we submit, is more consistent with the statutory language and solves the machine gun problem. Because if you say in the machine gun provision, a frame or receiver is also regulated, and if one hole is all that separates a semi-automatic receiver from a machine gun receiver, it's hard to see how the readily standard would not also be applied there. I welcome the Court's questions.
Well, that was Pete Patterson's argument. Pretty powerful argument. I think there's a lot more he had to say, which we'll play in future videos, but that was the nice summary of what he had to say about why the ATF and the Department of Justice has simply exceeded their legal authority far beyond anything they're allowed to do. But the Solicitor General, Elizabeth Prelogar, got back up and was able to give a rebuttal, and here's what she had to say about Pete Patterson's argument and Jennifer VanDerStok's argument against the ATF's regulation. This is Solicitor General Elizabeth Prelogar arguing in favor of the federal government here.
Rebuttal, General?
Thank you. Mr. Chief Justice, I want to begin with the question you asked about why manufacturers would leave these holes undrilled. You said, what is the purpose? My friend responded that it's to create a kit that hobbyists can put together. I think that that's a questionable proposition, given that if it only takes 20 minutes, the hobbyist is probably not going to get his money's worth and won't actually have the experience of building a gun. But I also think it's contradicted by the facts on the ground, because what the evidence shows is that these guns were being purchased and used in crime. They were sold to be crime guns. There was a 1,000% increase between 2017 and 2021 in the number of these guns that were recovered as part of criminal investigations. And it makes perfect sense, because the whole reason why you would want to get your hands on one of these unserialized, untraceable firearms is if you are a prohibited person or you want to use that gun in a crime. And more fundamentally, if there is a market for these kits for hobbyists, they can be sold to hobbyists. You just have to comply with the requirements of the Gun Control Act. Someone who is lawfully allowed to possess a firearm and wants to build it can purchase that kit if they undergo a background check. And so if there is a market for these products, they can operate under the statute. The evidence shows that actually the market for ghost guns essentially collapsed after this rule was permitted to go into effect, which I think just underscores what was evident all along. The reason why you want a ghost gun is specifically because it's unserialized and can't be traced. On the question of a frame or receiver, Justice Sotomayor, you asked questions about exactly what standard governs here, and I think it's helpful to break down the interpretive question into 2 points. The first one is, this is an undefined term in the statute. Does it require the weapon to be functional? We think the answer to that is no. If you are missing a single hole, then you can clearly recognize that as an unfinished component part of a weapon, and it is readily convertible to function, and that fits within the plain dictionary definition of what a frame or receiver is understood to be, no different than a bicycle missing pedals or a tennis racket that is sold unstrung. We have a picture of this on page 34 of our brief, what these frames and receivers look like, and it's hard to know what else to call them because they look exactly like the principal structural component of a gun. But that just raises the follow-on question. Okay, if it doesn't have to be functional, exactly what standards should you use to measure when it is a frame or receiver regulated by the statute? And there are good reasons why ATF focused on whether it can be readily convertible. First, that's most consistent with how Congress has approached this issue when it has defined terms under the federal firearms laws. That's the standard that Congress itself uses to mark the terrain of what products are regulated. Second, there is a consistent agency practice here of applying that readily converted standard. My friend several times tried to suggest that the 50-plus years of agency practice instead focused on whether it has reached a critical stage of manufacture. But that's ignoring the actual elements cited in the classification letters. They looked not just at what had been done to the gun, but what steps remained, how much time it would take to perform those functions, what equipment you would need to make that functional, what kind of skill you would need, and whether there are other parts. None of those elements go to what has already been machined on that particular frame or receiver. Instead, they are centrally relevant to whether it can be readily converted to function, just as the agency has said all along. For a third reason, that means that this is a standard that is familiar in the law and familiar to industry. I think it's really notable here that we don't have the major gun manufacturers suing us about this final rule. And the reason for that is because this readily converted standard is the one that has governed their conduct ever since the Gun Control Act was enacted. That also means that there is a stable body of judicial precedent and agency practice to draw on here in further answering concerns about whether particular types of products will be regulated, which I think Justice Kavanaugh also answers some of the concern about how the regulated parties will know whether their conduct falls within the scope of the law. Finally, in thinking about respondents' primary argument here, which is that a single undrilled hole is enough to exempt a product from regulation, I think the court doesn't have to blind itself to the practical ramifications of that rule. The agency's interpretation reflected in this rule is the status quo. It is how the law has been applied over 50 years. And if this court now says that one undrilled hole is enough to exempt these products from regulation, then that is going to be a sea change in how the Gun Control Act is implemented. At that point, it can't serve out its function because all manufacturers everywhere could simply exempt their products from regulation through that simple expedient. And that means that going forward, all guns could become ghost guns. This court said 200 years ago in the Emily that you don't have to interpret a statute to be self-defeating like that if there is a plausible alternative construction. Our construction is not only plausible, it is the best reading of the statute looking at text, context, purpose, and history. So I'd encourage the court to say that and reverse the Fifth Circuit.
Thank you, General Counsel. The case is submitted.
So there you have it, folks, the back and forth. Again, I'd always like to play these excerpts from you so you can hear what people are saying in courts of law. It makes you as smart as possible by giving you a little peek into this fight. We'll play some more clips from this argument in the future. But again, this is a good summary, and we will see what happens. We're probably not going to get a decision on this until perhaps May or June of 2025. And what's interesting, as I mentioned at the top of the show, if Donald Trump becomes the next president of the United States, which would be good for the Second Amendment, and he picks the proper Attorney General and the Solicitor General to replace, for example, Elizabeth Prelogar, who you just heard from in this argument today, guess what? It's quite possible that this regulation could simply go away and be removed, not by virtue of a Supreme Court decision, but by the executive action of a new Trump administration. Now, will this occur? I don't know. Will Donald Trump be elected to the White House? Well, I hope so, but I don't know that either. So only time will tell. But anyway, just something to keep in mind as you reflect on what I just played for you. And again, make sure you follow me at X. A lot of additional information I put out there about guns and the Second Amendment at 4 Boxes Diner. And don't forget to follow me here. We're trying to expand the channel as best as we can. Don't forget to like this video, and we will see you again very soon here at the 4 Boxes Diner.
Orders up. Table 2A.